Welcome to Minority Voices. I am your host, Alice Green. This year marks the 40th anniversary of passage of the 1964 Civil Rights Act, and next year will be the 40th anniversary of the passage of the 1965 Voting Rights Act. And as we look back and assess the state of civil rights in this country after 40 years, we must raise concerns about continuing problems such as poverty, unemployment, and housing discrimination, dysfunctional schools, disproportionate incarceration of African Americans, and a growing disenfranchisement of people of color. Now, we're going to look at one of those concerns, the disenfranchisement or the denial of the right to vote. And one of the major groups in our society that remain disenfranchised are persons with felony conviction records, and most of them are African American, Latino, and other people of color. Much of the public shares the misimpression that after one has served one's time in prison and their debt to society has been paid, that all rights and responsibilities are restored. Well, it's not the case. In most states, felons are either limited or permanently barred from voting. This is an important topic, not only because this is a presidential election year, but because the United States prides itself on being a beacon of democracy in the industrialized world. And at the core of our democracy is the principle of universal suffrage and the principle of one man, one vote. But more than 4.6 million Americans cannot vote because of their conviction records. The majority, as I have already stated, are African Americans and Latinos. There are many, including sociologist Christopher Uggan at the University of Minnesota, who have demonstrated conclusively that Al Gore would have won the popular vote in Florida and the U.S. presidency if ex-felons had been able to vote. Now, 1 in 3 or 33% of African American men in Florida were permanently disenfranchised, and George W. Bush became president. This points out how crucial it is that we examine this issue. I should also mention that there are 7 states, and I think I'm correct, that permanently revoke the voting rights of prisoners, regardless of the nature of their crimes or their ages. This means that a 16-year-old convicted of a one-time drug offense, for instance, in one of those states, would never be allowed to vote during his or her lifetime unless by some miracle they received a pardon. All states limit the rights of felons to vote with the exception of Maine and Vermont. And in those states, prisoners are allowed to vote. How is this denial of voting rights affecting civil rights and the voting strength of African American and other communities of color? Should felon disenfranchisement be a criminal matter at all? And why do some advocate strenuously for felon disenfranchisement? Historically, how did this country come to limit the right to vote for felons? We will discuss these and other issues with my guest, Joseph Jazz Hayden. Mr. Hayden is project director for the New York City Unlock the Block campaign, and he's the lead plaintiff in the class action lawsuit challenging felon disenfranchisement in New York State in a case Hayden versus Bataki, which he filed pro se and which is now being represented by the NAACP Legal Defense Fund and others, I understand. Listeners may have heard him on NPR, where he was recently profiled for Whose Vote Counts, a piece on felon disenfranchisement. I first became aware of Mr. Hayden when he sent me his wonderful essay entitled Unfinished Business, the Franchise, in which he takes a hard historical look at felon disenfranchisement. So I want to welcome you, Mr. Hayden. I want to ask you first, how did you become interested in this issue of felon disenfranchisement?
Actually, I probably, it began in 1992, somewhere closely around that. I completed that piece that I sent you on, that was the product of the research that I had entered into around 1992. Product of that was the piece I did on unfinished business, the right to vote. What had happened was, in prison, people tend to think of prisoners, in terms of the stereotypes that they see in the mass media and on television and the series Oz, and that prisoners are essentially non-thinking, driven by their lust and and selfish desires.
Violent people who
people,
do all kinds of
who need to be
destructive things.
kept in cages and do destructive things and just sing and beat on the bars all day. And this is as far from the truth as it can possibly be. In prison there are men in there just like men and women, just like you and I. Well, of course I've been there, but they don't fit that stereotype. There's men in there that are socially conscious, politically conscious, and very concerned about the things that are going on in their communities, that are going on in their state, going on in the nation, going on in the world. We have Renaissance men in there. We have men that think and they study and they do research. Well, a group of us got together and we looked at the circumstances that we found ourselves in, especially in the light of what took place at Attica and the events that followed it. It seemed like all the gains that flowed to prisoners in New York State after the rebellion at Attica, all the programs and higher education and all these things that emerged out of that catastrophe were being taken away one by one. And as they were being taken away, the ultimate piece was the taking away of higher education, which finally gave prisoners an opportunity to really make a significant change in their lives. Men began to look at the prisoners' response to these things were basically to petition, to write letters, and they found themselves in the position of being beggars. And they began to look at the power relationship between prisoners and the state, and they saw that the state had 100% of the power and prisoners had zero, So naturally, thinking people would, in a situation such as that, would begin to reflect on how to change the power relationship between prisoners and the state. And so this is what informed our research, and we looked at prisons, went back to look at prisons from ancient times all the way up to the present, right? And we followed the history of prisons through the United States, how it started with the Quakers and the penitents and the, and
it's actually seen as a reform at that time, right?
Yeah, it was seen as an improvement over the way that justice was meted out, putting people in the stock, public whippings, public hangings, and so they thought the penitentiary was an improvement over that. But in fact, the system that they had set up was one of penitence. It was set up on the order of a monastery, and prisoners were reduced to a code of silence. And men were going crazy in this, So they switched from that. They switched to putting vocational training in there and jobs, and then they began, created the reformatory. And this movement towards the humanizing of this institution went on up until, say, about the 60s. And when the population shifted in the prisons, the population shifted from predominantly white to predominantly African American and other poor people of color.
Are you talking about overnight, or was there something going on?
Well, say like in 1923, say the prison population of African Americans was something like 20%, something like that, even though their percentage in the population was which has been constant down through the years, was about 12% or something like that. And 70-something% Caucasian, white. Well, that shifted dramatically to the point where African Americans, Latinos, and other poor people of color represent over 85% of the prisoners in the New York State prison system, and whites occupy anywhere from 13 to 19% or something like that at best. So, and as this shift took place, the way of looking at prisoners shifted also. And so we shift from this reformatory mode and trying to in rehabilitation mode, we shifted into this punishment mode, right? And punishment and what's the other word? Well, actually,
retribution type.
Yeah, retribution. You know. So this shift reached its peak around the early '70s. You know, and this is when we had the prison movement in this country began to flower all over the country. George Jackson, the number on the West Coast, and you know, Attica, and different prison actual prison movement began. You know, men begin to think. You know, they begin to turn out more Malcolm X's than you know. It became he became the model of what was taking place around.
Was there a
the country.
relationship with the civil rights movement that was going on at the time?
Oh yeah, definitely. You know, because prison populations essentially reflect what's going on in the communities outside. So as the results of the struggles in the '60s, in the Vietnam anti-war movement, student movements on the campuses, the Black Liberation Movement, the Civil Rights Movement, you know, in the state's response to this was by arresting these people and putting them in the, you know, running them through the criminal justice system and putting them in the prisons. So now you have this really politically conscious group, and you're mixing them, you know, with the underclass, you know, the lumpen proletariat as they were referred to at that time, you know, and you know these people, you know, this was a volatile mix, and essentially that's what was in Attica prior to the rebellion. So, in any event, the events took place at Attica. The state, in its response, was to open up the system. You know, contact visits, higher education, educational release, vocational training. You know, they went back to the reform model. You know, but while they went back to the reform model, they also began to expand the prison system. You know, we had the war on crime, and then we had the war on drugs, and before you know it, the prison population, which was about 2,300, say in 1972, 73, we looked up today. It's anywhere from 67 to 72,000 in New York State, and in the country, it's reached 2.1 million people that are in prisons and jails across this country on any given day, and that's just a snapshot on a given day. And this you know, this population is constantly evolving. It's like a turning door, so maybe anywhere 4, 5, 10 million people might be passing through this criminal justice system in a given year.
Right. So we're not just talking about prisons. We're talking about probation, parole. But
we're talking about the people that are incarcerated. Is like 2.1 million.
Right.
Yeah.
In the all of the.
Then we got another 4 million out there on probation and parole. You know, and essentially, what has happened as a result of this massive incarceration, coupled with the felon disenfranchisement statutes in the 48 of the 50 states, what we have is a massive disenfranchisement of that population, which has. But now
this is something that you learned about as you were doing the research that prisoners were engaged in following Attica.
Yeah, as a result, that research actually began after Attica. You know, a good friend of mine named Larry White, I think he's a member of the board.
Yeah, he's a member of the board of the Center for Law and Justice.
Center for Law and Justice. Yeah, he's in prison right now. He's still in prison. He's very sick. And results of his analysis, you know, which showed that there was a direct relationship between the criminal justice system in 7 specific communities in New York City, you know. And the relationship was that, you know, the majority of the prisoners in New York State prisons came from these communities, you know, and not the surrounding communities or any other community, but these 7 specific communities was like the feeding ground for the criminal justice system, you know.
You're talking about there's 7 communities from across the state?
No, across the state is a little larger, but speaking specifically about New York City, there was 5 neighborhoods in New York City. You know, South Bronx, Harlem, Lower East Side, Bedford-Stuyvesant, Brownsville, East New York, South Jamaica, you know, and essentially those were the communities that the majority of the prisoners came from, right?
And I would imagine that the rest of them would come from the other urban centers across the state.
Yeah, across the state. Albany. I guess you know more about the upstate communities than I do, that are most impacted by this. Well, in any event, as a result of this research, we saw that the only way that we could change the power relationship between prisoners and the state was to by getting the right to vote. Because one thing our research revealed is that when people are convicted of crimes, they don't lose their citizenship. They continue to be citizens of the United States. And what is the most fundamental right of a citizen of the United States is the right to vote. And losing the right to vote has absolutely nothing. The right to vote has absolutely nothing to do with conviction of a crime. It has nothing to do with the criminal justice system. And then when we discovered that in 4 states at the time, it was 4 states, it was Maine, Vermont, Massachusetts, and Utah, never took away the right to vote of their prisoners. Prisoners would retain their right to vote. And then we looked at the law in New York State. The law in New York State says if you're convicted of a felony and you're sent to prison, you lose your right to vote. But if you're convicted of a felony and you're given probation or some other non-incarcerative sentence, you retain your right to vote. So 2 people go out, commit the same crime, and get convicted in the same court, and one is sent to probation and one is sent to prison. The one that's sent to prison loses his right to vote. The one that's sent to probation retains it, even though they were equally culpable in the crime.
Or
right?
you could also, if you're in a different state and you commit the same crime, you still might not lose your right to vote if you're in Vermont.
And you wouldn't lose your right to vote at all. So this is, contradictions here are so glaring. So if you tried to approach this with a logical mind and try to make some, well, listen, the only reason I lost my right to vote is because I went behind a wall. What is going behind a wall have to do, why does that make me eligible to lose my right to vote? When this guy that I committed the same crime with, he just goes to the street or probation or whatever the case may be, and he retains his right to vote. So when you look at the legislatures around the country and the each state, because Congress, the Constitution gives the right to vote, determine the eligibility of voters to the states. Out of all the states have shaped their own voter eligibility laws. So, as you look around the states, there's, it's like it's like a fruit salad. It's just none of them, all of them are different. There's some specific patterns. In some states, you're disenfranchised for life. Other states, you lose your right to vote if you go to prison or if you're on probation or you're on parole. In other states, you lose your right to vote only if you're in prison or on parole. In other states, you lose it if you're on parole or in prison, but if you're on probation, you retain your right to vote. And then, of course, we have those 2 states where you never lose your right to vote.
So it's a big mix.
Yeah,
so when you were doing the research for this, I would imagine that a number of prisoners became extremely angry when they looked at their own situations and found that they did not have the right to vote.
Yeah.
And did you also look historically where all this came from? How did we get to the point that we disenfranchised? Somebody thought it was wise to disenfranchise prisoners.
Okay. Yeah, I like that. That's a good question, Alex, because the people that generally oppose prisoners having their right to vote, whether you refer to them conservatives or whatever the case may be, they tend not to want to look at the historical record, But if one looks at the historical record, you'll see that these laws were rooted in, they were essentially rooted in slavery, feudalism, when this Constitution, this country was founded in the Constitution, the only eligible voters in America were 10% of the population, and they were white male property owners, not even women. Women, white women were given the right to vote, or poor white people who didn't own property, who couldn't meet the property requirement, were eligible, had the right to vote. And of course, slaves and Indians and other people in this country were not eligible voters. right? And as in this country here, free black property owners had the right to vote. But in New York State in particular, there's a book I'm reading now. It's called Jim Crow, New York, and I recommend this highly to everybody within earshot of this program here, or that's interested in this subject. And it's a book that just came out recently. It tracks the history of Jim Crow in New York, and all the way back in 1774, in the 1800s, they begin to devise methods to keep even free blacks from getting to the polls. You know, the
property, right?
Yeah, the property requirement was twice as high for them as it was for whites, right? And so this thing is rooted in all the way back in the history of this country here. But it really took off after the Civil War, you know, after the passage of the 13th, 14th, and 15th Amendment, when the 13th Amendment freed former slaves, freed ended slavery, with the exception of those convicted of a crime. The 14th Amendment
carves out an exception.
Carved out an exception.
We don't usually think of the 13th Amendment that way. It's
No. Yeah, people, when they speak of the 13th Amendment, they generally think of the emancipation of slaves, the end of slavery. But it didn't end slavery. You know, with cancer, if you don't cut it all out, it will, reemerge, and that's exactly what that exception has done. You know, because slavery is allowable in this country if you're convicted of a crime, penal servitude. You know, so with the passage of the 13th Amendment, what essentially happened is we went from the private ownership of slaves to state ownership of slaves. And the state now has about 2.1 million of them. You know, and I think when the Civil War was over, they freed 4 million slaves. They freed 4 million slaves. So give it a little more time, and they'll have need another 2 million. They'll have completely reversed that process there, right? Mm-hmm.
But for a time after the Civil War, African Americans did start to vote.
Oh yeah, absolutely. Well, the whole reason for giving them the vote in the 14th Amendment and the 15th Amendment was because the North had won the Civil War. They had won the battle on the battlefield. But there was a chance that they might lose it in the Congress if they couldn't find enough votes to outweigh, the vote, the Southern vote, right? Because I think in terms of sheer numbers, there were more people in the South than there were in the North, right? So what they did was give the slaves the right to vote, and that was in the 14th Amendment, okay? Mm-hmm. And that amendment, that exception that was carved out in the 13th Amendment was repeated in Section 2. Yeah, in Section 2 of the 14th Amendment, right. Except for rebellion, those that were involved in rebellion or convicted of crimes.
Mm-hmm. So again, that's something that we don't hear about in our history. I mean, the student in a high school learning about the 13th and 14th Amendment, we don't stress those two exceptions that you're talking about.
Exactly.
Which takes away the right to vote for a number of people. And
it was hard to believe, man, in an institution that prides itself on, or that everyone knows is usually staffed by lawyers and some of the best educated, best trained minds in the country, that them two exceptions were put in there inadvertently or something like that. In any event, that exception was repeated again in the 14th Amendment. And it's played a significant role later on in litigation when we get to talking about the legal status of felon disenfranchisement. We should be talking about that. Well, in any event, it was in the North's interest to see that the former slaves got the right to vote because they would vote for the Northern Republicans who had liberated them, past the 13th Amendment. And so when former slaves were given the right to vote, they voted. And they were represented on every level of government, local, state, and federal, all across the South, And they were passing laws. They were making laws, I think they even were responsible for starting the public school system. Freedmen, they had a Freedmen's Association, and they were very successful. And this went on until 1877, when they had elections somewhat similar to the one in 2000 between Gore and Bush. And it was a close election, and it was a disputed election. I think the two candidates were two guys named Tilden and Hayes. And they referred to this election as the Southern Compromise. It was at this time here that the Northern Republicans, in turn, for the Southern Democrats ceding the presidency to them, they in turn would remove the Northern troops from the South. And the Northern troops in the South were there essentially to protect the former slaves and to see that they had a chance to exercise their rights as citizens and their access to the ballot box. And once they removed the Northern troops from the South, that was it. All of the gains made as a result of the Civil War by 1903 were completely reversed, and I think there was something like 3 elected officials left in the entire
What
nation.
about the 15th Amendment itself? I mean, that gave everyone the right to vote, if you're a male.
Yeah.
That is. The right to vote. How does that come to play?
Well, the way they circumvented the 15th Amendment is they couldn't do it directly. Mm-hmm. So what they did, the state legislatures, particularly throughout the South, they passed these laws that appeared to be facially fair. You know, what they did was they looked at the kind of crimes that former slaves were most likely to commit, and they criminalized that behavior. They looked at their behavior and they criminalized it. Here you got 4 million people coming out of slavery. They own no property. You understand? For the most part, I mean, they had some skilled labor, but plenty of unskilled labor. And so they had no property. They tended to be homeless, moneyless, and they tended to engage in petty crimes, wife beating, domestic type of crimes. And so what they did, they criminalized that behavior. You'll find that this is a pattern throughout American history. Just like when they got tired of the Chinese after they finished building the railroads and began to compete with white labor, they criminalized what had become a cultural behavior of theirs, was the opium dens. So, they outlawed opium, and they did the same thing with the Mexicans and with the marijuana and the cocaine with, African Americans drinking soda pop, And so this is what they did with African Americans, and they criminalized it.
I remember that one or more of the states in the South actually had, in looking at the kinds of crimes that African Americans were most likely to commit, someone found that persons who committed murder, which was not African Americans, but whites, and so they were not disenfranchised.
Exactly.
But people, particularly African Americans,
committed petty crimes,
who might beat their wives or something like that, they were no longer
they criminalized that. Well, they knew that African Americans, former slaves, weren't prone to that type of violence, the murder and major types of crimes. So they didn't criminalize them. They criminalized just the type of crimes that were characteristic of people in the condition that they were in, right? And when they passed these laws, the laws on their face were fair. They applied to everybody, but in practice, they were targeted at this particular population, right? Just like the drug laws today. On the face of the drug laws,
right.
It says anybody caught in possession of such as, they're racially neutral. Mm-hmm. But when we look around, say like in New York State, people use drugs, different groups in New York State use drugs in proportion to their numbers in the population. So our African American use of drugs would be something like 12.4% or 15% or whatever the case may be. Yet we find out they represent over 97% of those that are arrested, convicted, and put in prison for drugs, whereas whites represent 77% of the population. And if they use drugs, and they do use drugs in proportion to their numbers in the population, right. Yet they only anywhere from 6 to 9% of those that are arrested and convicted and sent to prison for drug use. So essentially, what they did then, what they're doing now, they did then.
Okay.
The frame changed, but the picture's the same.
So states could determine the criteria for voting.
Exactly. And so in the South, then and some legislators even went so far as to put it in the legislative record exactly why they were doing passing these laws, and it was to maintain white supremacy, or to keep the former slaves away from the ballot box. In those cases where you could find it directly in the record, you could challenge it under the 14th Amendment under intentional discrimination, right? Which is what you need to prevail on the 14th Amendment argument.
I want to remind our listeners that this is Minority Voices. I'm Alice Green, and I'm talking to Joseph Jazz Hayden, who is project director for the New York City Unlock the Block campaign, and he is concerned with the whole issue of the disenfranchisement of persons who have felony convictions. So you were telling us about what happened in the early part of this country, where states determined the criteria for voting, and that there were laws put into place that were racially neutral on their face, but the impact was certainly directed at African Americans particularly. Yeah,
it disproportionately impacts in African Americans, and so after this brief period of exercising the right to vote and the using of it, and then taking away of it, by these state legislatures, we saw all states throughout this country pass, with the exception of those 4 states that I mentioned, Maine, Massachusetts, Vermont, and Utah, passed felon disenfranchisement laws. And so that now we look today in all of these states, with the exception of those of 2 states that are left, Maine and Vermont, the numbers of African Americans that are disenfranchised in those states have reached a point where there's 4.67 million African Americans, 1.4 million African American males that are disenfranchised, and 4.67 people that have been convicted of felonies that have been disenfranchised.
What do you see that the impact of this is on communities, and what does this tell us about the African American relationship to the larger community?
Well, up until recently, before people became aware of this issue, and let me say one thing about this issue of felon disenfranchisement. The ignorance around this issue is virtually universal. Very few people. This only really came to full public attention after the 2000 election, and the awareness that the election could have turned out differently had people with felony convictions been allowed to vote. And suddenly it's become, it's the civil rights issue of the 21st century. But this felon disenfranchisement issue, people didn't understand that every time that a busload of prisoners left their community, they didn't understand that that was also a busload of votes. And that as the numbers grew, their political power was diluted, the political power of those communities. And because their political power was diluted, their ability to assert their interests through the political process weakened and weakened. And especially in New York State, let's talk about New York State, New York City. Specifically in this state here, people tend to vote the voting practice in the state tends to be racial block voting. People tend to vote with the group that they identify with, right? So if this is the practice, and you find out of all the groups that participate in the political process, 1 or 2 groups are having their political power diluted, on a systematic basis, right? Then those groups are less able to compete in the political process, right? And you see this reflected in the conditions in which they find themselves, in terms of school, health care, employment, opportunity, you name it. And you find that on every index of social misery, those communities are at the top, right? And this is the direct results of the weakening of their ability to participate in the political process. Right?
And it sounds like that's what really concerned you and other prisoners when you looked at this research and decided that there was something you had to do.
Yeah.
And I know that you were involved in a lawsuit. Have there been 2 lawsuits?
Yeah. At the time that we were doing this research in the early 90s, there were 2 groups of prisoners that were doing this research. One group happened to be in Greenhaven Prison. The other group was in Easton, with myself. And we were pretty much unaware of what the other groups were doing. So, it was the idea whose time had come. The first prisoners actually challenged these felon disenfranchisement statutes under the Voting Rights Act. Came out of Tennessee in a case called Wesley versus Collins. And I think there was another case, I forget exactly, I think it might have been out of Alabama, where it was Hunter versus Underwood. They challenged felon disenfranchisement under the 14th Amendment because in the legislative history of that state, the legislators clearly stated that this was the purpose for passing those statutes. And ultimately, those statutes were overturned there, And in Wesley versus Collins, where they challenged it under the Voting Rights Act, their petition was denied in the district court, on the grounds that the criminal justice system, the decision couldn't be decided on the basis of discrimination in the criminal justice system. And they appealed it to the Court of Appeals, and it was affirmed. And I later contacted the lawyers that were representing that case, and they said that they were afraid to go to the Supreme Court because of the way the composition of the Supreme Court at that time. They didn't feel that they could get a good decision. That was in 1985. So we were building off that precedent. They had set the precedent, and we began to work on that. So we had these 2 teams of prisoners doing research on this at the same time, but the team of prisoners in Greenhaven had the assistance of the Yale Law School, or some students out of Yale Law School working with them. And so everywhere I went to do research, I went down to Tennessee, I wrote down to Tennessee trying to get to contact the lawyers down there, and they say, hey, this guy, Andrew, I can't think of his name, law student, he was already there, and we gave him the information. They said, well, all right, well, send me a copy of whatever you gave him. So we moving neck and neck towards the finish line, and they got there first. and so they filed their class action claim, and the prisoner that was the lead plaintiff on that was a guy named Baker, and it was a case called Baker versus Pataki. So the Baker
was there one before that? No,
that was the first one.
Oh, okay. I thought there was one. I thought Cuomo was on one of those.
Yeah, well, it was Baker versus Cuomo, but then Pataki came in office, and they shifted to Baker versus Pataki.
Okay.
And so the case was dismissed in the district court without even really giving allowing due process to take place there. And 3-judge panel in the Court of Appeals reversed it, and then the state appealed and asked for a rehearing in bank, which is a hearing where all the judges sitting on the circuit sit down to decide the issue because it's an issue of major importance to the state, right? And so they had 10 judges sit down and read the arguments on both sides of the issue, and the state opposed it, of course, and the prisoner side, claiming that this was an issue that was covered by the voting rights, because the voting rights says that any electoral device or mechanism that disproportionately impacts on a protected population falls under this act. Well, the 10 judges sat down and they split down the middle, 5-5. 5 were for the prisoners and 5 were against. Mm-hmm. And the guys that were against the prisoners essentially made the same arguments that the South made before the Civil War, talking about states' rights and which was really a concession to southern states when they made the Constitution. This was a concession to them because they didn't want a strong federal government, and they figured the only way they could protect the slave system in the South was by each state retaining its rights. So in any event, because it was a draw, 5-5, one of the judges said, I think his name was Judge Feinberg, he said, well, there's nothing to prevent another group of prisoners coming forth and litigating the same claim, right? So in the year 2000, on September 13th, the anniversary of Attica in 1971, I filed another class action law claim challenging felon disenfranchisement. And it was accepted. And when I came out, I hooked up with 3 law firms, the NAACP Legal Defenders Fund, the Community Service Society of New York, and Medgar Evers Center for Law and Social Justice, and we litigated. And we expanded the suit not just to cover prisoners, but we cover parolees, and we cover the communities from which they come, which it makes our suit very unique. We have a class of petitioners from the communities from which the majority of the prisoners come. And then we have the parolees, and then we have the prisoners. We challenged in these statutes under the 14th Amendment, under the Voting Rights Act, and under international law.
Well, explain about the Voting Rights Act. What's your challenge under that?
Well, the Voting Rights Act...
You're talking about New York State's... you're challenging New York State's Voting Rights Act.
We challenged in the felon disenfranchisement statutes in New York.
In New York State.
New York
right.
State. We're saying they're unconstitutional and that they're also in violation of the Voting Rights Act and international law.
Okay, the Federal Voting Rights Act.
Federal Voting Rights Act, passed in 1965, amended in 1982. Amended in 1982 so that, you not only, prior to that, it was interpreted that under the Voting Rights Act, you would have to show intentional discrimination. Okay, but it was amended in 1982 to make it clear that all you have to show that a voting practice or device results in discrimination and disproportionate impact, right? So that means that we don't care what you intended it to do. This is what it's doing. So it's more like like an environmental protection. What do they call that? Environmental impact statement when they ask before you put a dump in somebody's community. Well, this is a racial impact statement. So if this thing is violates.
And what kind of information are you using to make that claim? Are you
to make the claim?
Yeah.
Well, primarily it's the criminal justice system in New York State clearly operates in a racially discriminatory at every stage of the proceedings, man, from arrest to conviction and all its practices. The system disproportionately incarcerates, arrests, convicts, and sends to prison African Americans and Latinos, out of all proportion to the numbers in the population. I mean, these populations are clearly targeted by the criminal justice system. I mean, what are you telling me? That 70% of the drug users in New York State are white, yet 90-something% of those arrested, tried, and convicted are African Americans and Latinos? I mean, are drugs legal in the white community? Of course not. But this is a product of a racially biased and discriminatory criminal justice system. This is how the criminal justice system operates. And I mean, it's beyond dispute. Studies have confirmed this.
And probably a lot of the stuff that you started looking at when you were in prison, the research that's being used and it's helpful to you now in making your claim.
Absolutely. Yeah, all of this stuff. I mean, all of these suits that have been initiated across the country, they have a suit in the state of Washington now called Farrakhan. Started out as Farrakhan versus Locke. Now it's Farrakhan versus the state of Washington. A group of prisoners in that state initiated this lawsuit, and it's the same lawsuit that I initiated and Baker initiated in New York State. They also have suit in Florida, and there's challenges to these statutes all across the country, in the courts and in the legislatures, and now in New York State, we even challenge it on the ground,
What do you say to some of those who are opposed to prisoners having the right to vote, and to people who have been formerly convicted and are now out having the right to vote? They sort of make the argument, well, that these people have violated the social contract, and they should definitely not be allowed to vote. They've not, they've lost that right, and they shouldn't participate as other citizens do.
Okay, that is based on position taken by a couple of philosophers, John Locke and Jean-Jacques Rousseau, about the social contract. Well, where were we, African Americans, when the social contract was written? Huh? We were in slavery. Mm-hmm. We had absolutely nothing to do with this social contract, okay? And if you look at the legislatures, you look at the Congress of the United States, and you look at the legislatures in every state in this union, and you look at the composition of those legislators, you don't see us. We represent it in token fashion. We don't make the laws. We don't make the social contract. These laws were passed by white male in this country for the specific purpose of maintaining the status quo and keeping African Americans out of the political process. For that short period that we were allowed to vote after the Civil War, we represented the swing vote in this country here. We were the swing vote between Republicans and Southern Democrats. You understand? And they got together, and the Southern Democrats told the Northern Republicans, say, man, how are we going to allow it? I mean, they're more powerful. Essentially, they're the ones that are deciding who's going to be running the country. And so they wanted to eliminate that swing vote. And they do to this day. Look at the primaries that they just had in the last few weeks, last month or so. They started out with primaries in Iowa, and what's the little New England?
New Hampshire.
New Hampshire. Ain't no black people in Iowa and New Hampshire. Ain't no people of color there. Their numbers are minuscule. What? Are those states representative of the electorate in this country here? I mean, they don't intend for us to participate in this process. Social contract, hey, come on, let's be for real.
Yeah. I know you've been doing more than filing a lawsuit. You're now project director for the New York City Unlock the Block campaign. Can you tell me what that's all about?
Okay, the Unlock the Block, Release the Vote campaign is a product of, while the case is being, Hayden versus Pataki is working its way through the courts, what do? Do we sit around? We know how litigation in the courts are. You file a claim, they move for dismissal, you answer that, and, the motion papers go back and forth for years before you finally get to a point where the case becomes pregnant for resolution. And this, they anticipate, will be some 2005. So what do? We sit around and just twiddle our hands and wait for the litigation? No. What we found out, that there's two types of disenfranchisement in this country. There's de facto disenfranchisement, and there's de jure disenfranchisement. Now, litigation is addressing the question of de jure disenfranchisement, and the campaign to restore the right to vote to people who have completed their sentences and are eligible to vote, but don't know they're eligible to vote simply because they've never been informed at any stage throughout the criminal justice process that they lost their right to vote, or what they need to do to get their right to vote back. I mean, literally, nobody knows. I was addressing a group of the NAACP at the state convention, the annual state convention of the NAACP in New York, and I'm talking to a group of its members, and there was a Supreme Court judge sitting in the first row. And I was talking about the felon disenfranchisement law in New York State, and the judge interrupted me, and I'm saying that, prisoners are not informed of their rights at no stage during the proceeding. And the judge said, I beg to disagree with you. She says, every time I sentence somebody to probation, I inform them that they lost their right to vote and what they have to do to get it back. And I sat there and I paused and I froze for a
Found
minute.
this to be true.
And then I said, well, I got to answer this woman. And I said, listen, Your Honor, I think you're mistaken. In New York State, you do not lose your right to vote when you are sentenced to probation. Now I did this with some hesitation, because I'm still vulnerable. I might end up in front of her. She said, "Oh, you the guy," okay. But in any event, she was silent from that point on. But I only bring up this point to show the level of ignorance around this issue here. Here's a Supreme Court judge. She done went through law school. She done passed the bar. She probably was in private practice, clerking for Supreme Court judges. And finally she becomes a Supreme Court judge, and she's passing, justice out. And she doesn't know the law.
And I found this to be true, too. I've talked to judges who were mistaken about the law in New York State. You're absolutely right.
Yeah, well, that's universal. It's all across this country. So part of our the campaign, our work is one of our goals is public education. Mm-hmm. Let me tell you how this campaign came about and this coalition came about.
Maybe before you do that,
okay,
we want to make sure that our listeners understand clearly what New York State law does say regarding felony convictions.
Okay, felony convictions. The law says that if you're convicted of a felony and you're sentenced to prison, you lose your right to vote until the completion of your sentence. While you're in prison or while you're on parole, until you're released from parole, you lose your right to vote. If you're sentenced to any other non-incarcerative sentence, you do not lose your right to vote, such as probation, suspended sentence, community work, or whatever the case may be.
But this means that people who are in jail on misdemeanor convictions or awaiting trial, they still have the right to vote. Is that correct?
They still have the right to vote. In New York City on Rikers Island, there's at any given time there could be 14.5 thousand people locked up. It's the biggest penitentiary in the world, Rikers Island. And in the rest of the state, especially up here in Albany and the rest of the upstate counties and the other county jails around the state, there's 15.5 thousand prisoners in the county jails. And for the most part, these people that are in these jails are eligible to vote. Because you only lose
many
the right
of them
to vote.
probably don't know that.
And they don't know that. And I'm quite sure that jail officials are not running around saying, it's election time, the primaries are coming up, the deadline's coming up, and we want y'all to fill out these registration forms, or we're going to give you absentee ballots, and we're going to see that you get to the polls. So this isn't happening. So we got 30,000 votes that are on ice, people that are eligible to vote. And if the statistics that we quoted earlier are consistent, these 30,000 votes come from these communities of poor people of color. And so they're voting, these people are de facto disenfranchised simply because they don't know that they can vote. And most people in prison think that when you're convicted of a crime, that you lose your right to vote for life. So we got all these untapped votes in our community that are not involved, not registered, not participating in the political process, and it's simply because of ignorance and a failure on the part of the system to inform people of their rights.
So that's what your Unlock the Block campaign is designed to do.
It's designed to do is to remove any kind of administrative or legal or institutional barriers to them exercising their right to vote or having their right to vote reinstated. And we were successful at doing this because we got the State Board of Elections to issue a memorandum to the 58 local boards in the state that they were no longer to ask prisoners for things such as release papers, certificates of relief, certificates of good conduct, letters from your parole officer. They are to be treated just like any other citizen. When they come to the polls and they sign that affidavit stating that they're eligible to vote, that's all that's required of them. If you have any further questions about that, you register them, and then you deal with that issue. If they perjure themselves, then they're subject to the laws of perjury.
Are there any legislation being proposed now that would help the work that you're doing in New York State?
Yeah. Keith Wright has a bill in the Assembly trying to, think it's to get the right to vote for people on parole or once released. No, not in prison. Just those on parole. New York, I mean, the lawsuit Hayden versus Pataki is the only lawsuit in this country, man, that's pushing the envelope all the way. That and Farrakhan versus Locke in Washington. That, our position here is, man, that these laws have no reason to exist. They should have been thrown out with the poll tax, the literacy test, the grandfather clause, the white-only primaries, But, when the Civil Rights, the Voting Rights Act and the Civil Rights Act were passed in 1964-65, everybody threw up their hands and said victory. Apartheid in the United States is over.
We've overcome.
We're full citizens. We've overcome. And, we reached the promised land. But this civil rights movement, when it got to the prison walls, it stopped. It didn't go over. And it left that one piece of cancer in there. And that was the felon disenfranchisement statutes. And that felon disenfranchisement statutes has effectively disenfranchised over 4.67 million people in this country here, more than any other nation in the world. America represents 5% of the population on the planet, and over, I think it's something like 40% of the prisoners on the planet are locked up in American prisons. And everywhere they go, they plan a prison. They watch Iraq and Afghanistan. Everywhere they go. And so.
Are you familiar with what might be happening in other countries? Are we one of the last industrialized countries that disenfranchise people with conviction records?
Without a question. Just the year before last in Canada, in a case called Salve versus Canada, the felon disenfranchisement statutes were challenged in that nation, in the Supreme Court in that nation. Canada's whole system is virtually a mirror image of the system in the United States. And the felon disenfranchisement statutes in Canada were challenged, and the Supreme Court ruled on a 5-4 decision that the right to vote was exactly that, a right, not a privilege.
Well, you've certainly enlightened us, and I think we're running out of time. I want to thank you, Joseph Hayden, for being our guest and talking about this really important issue. And we hope that our listeners will want to be involved. And is there a telephone number or an address or some way they can get in touch with you?
Yes, I can be reached at the organization I work for is Demos. It's relatively a think tank, and the phone number is 212-389-1406.
Okay,
212-389-1406.
Okay, thank you, Joseph Hayden.
And I thank you very much for having me.
Thank you.
Okay.